Good morning, everyone. Welcome to our webinar, Confused About the New Form I-9 and Alternative Procedures for Virtual Review. I'm Anna Beely. I'm the Director of Marketing and Business Development at WR Immigration. I'll be running the webinar today. For those of you who are looking to get SHRM credit for this seminar, please make sure to fill out the poll at the end of the webinar and indicate that you need the SHRM credit, and we will send it to you within a week. Additionally, we'll send a link to the video and the presentation slides within a week if you need to review them. I would like to introduce our speaker today, Kimberley Best Robidoux. She's an immigration attorney and a partner at WR Immigration, and she will be discussing all of the new Form I-9 procedures that you need to know in order to be in compliance based on the changes. So with that, I'll give it to you, Kim.
Thanks for taking some time out of your day. We are going to talk first about the end of the COVID-19 flexibilities, because although the deadline was yesterday, I know some people still have some questions. So hopefully we can answer some of those for you. And then we will move on to the I-9 stuff with the new form. So legal disclaimer, this does not constitute legal advice. It's for informational purposes only. And for legal consultations, please reach out to a WR team member or counsel. Our mission is to provide clients with the best experience through strategic legal services, predictive technology solutions, and inclusive collaboration, which includes all varying aspects of immigration law. A roadmap for today, we're going to talk initially about the end of COVID-19 flexibilities, and then what is the new form that was released on August 1st, the new virtual alternative procedure, and then a little bit about a proposed pilot program that will allow for virtual review as well. So let's dig in here. So it's past August 30th. Is that too late for the reinspection process? So what we're going to talk about here is, just from the very ground level, what were the COVID-19 flexibilities, right? So many of you know that between March 20th, 2020 and July 31st of 2023, our government, DHS, Department of Homeland Security, and specifically Immigration and Customs Enforcement, allowed employers to virtually review the employee's identity and work authorized documents. Initially, it was for companies who didn't have anyone working at the particular work site, which was really difficult because even the government said even if there was a security guard there was someone physically at the work site. But the government had a change of heart, and in April of 2021, they said that the virtual review could be used by employers to review the documents virtually for employees that were working remotely due to COVID-19. And unfortunately, what happened is that a lot of employers took that to mean any employee who was working remotely. And we know people started working remotely due to COVID-19. And then as we found out that it was actually really good in some situations and sometimes even more productive for people to work remotely, as well as being able to find wonderful talent throughout the United States instead of in one particular location, more employees were being onboarded that were only going to work remotely. So even if you have an employee that was initially, hired to work remotely, not due to COVID-19, we're looking at it from the perspective of complete the reinspection now, kind of group them all in together because it was a crazy time during those little over 3 years that we had this flexibility in place. One of the other things that employers were required to have is a written policy for the virtual or remote review of the identity and work authorization documents. If you didn't have such a policy, you may have overlooked that guidance from the government, given everything else that was going on. When you're doing your reinspection, I recommend put a written policy into place that says what, basically capturing what you did do. And then the reinspection had to be conducted by August 30th. That was the deadline that the government gave to us, which was yesterday. So why are we talking about it now? And why, what was required by yesterday? It was either a physical inspection of the identity and work authorization documents or virtually inspecting those documents through the alternative procedure that the government put forward through the Federal Register at the end of July when they posted that. Please note that the reinspection via a physical inspection or alternative procedure is only applicable if the I-9 documents, those are the identity and work authorization documents, were not previously inspected in person. So if they were inspected in person, great job. You don't need to reinspect them under the reinspection process. So what happens now, right, that we've passed August 30th? Department of Homeland Security, in their press release on July 21st, which is when we saw the unofficial publication of the new rule in the Federal Register, stated the following, and I'll read it so that everyone hears what DHS was thinking. If an employer is otherwise compliant with the law and regulation and had followed the COVID-19 flexibility guidance, U.S. Immigration and Customs Enforcement, which we refer to as ICE, will generally not focus its limited enforcement resources on Form I-9 verification violations for failing to complete physical document examination by August 30th, 2023, particularly where the employer can show that it has taken timely steps to complete physical document examination within a reasonable period of time. So for those of you employers who are struggling to do the reinspection for hundreds or potentially thousands of employees, now that it is August 31st, we strongly recommend to continue with your efforts to complete the reinspection process. So with that, we'll just go through a little bit rundown of what is the reinspection process. So you can either physically inspect the documents. In this case, a company representative or the authorized representative has to physically review the identity and work authorization documents in person with the employee, right? Side by side, sit with the employee, review, put the documents in your fingers, make sure that they reasonably appear to be valid on their face. And then the representative must note in the additional information field of Section 2 that the documents were physically examined on, and then put in the month, the day of the year, the name of the representative, and the title of the representative. If the representative conducting the physical inspection is different than the representative who completed the virtual inspection when the employee was initially hired, then per USCIS guidance, the representative should note their full name and title in the additional information field. We recommend that regardless of whether or not it was the same person or a different person. But if you've already completed the additional information field and it was the same person and you've just used the initials of that person, that's completely fine as well. This is just, something a little bit extra. But if the person, the people are different, then make sure to use the full name and title. If the individual is not a company representative employed by the company, but rather an authorized representative, their title will be authorized representative. And then one thing to note is that ICE has actually commented that they prefer that employers complete a new Section 2 so that the individual who's now reviewing the documents, who did not initially review the documents at the original date of hire, is signing the certification under penalty of perjury. Again, that's a recommendation by ICE, but it is not something that USCIS provided in their guidance. So if you've already started your reinspection process and you're doing the physical inspection and you've just been updating in the additional information field, that is fine. This ICE comment is really a suggestion on their part. So let's move on to the next slide. We can talk about the example, right? So this is on the version 1021-2019 of the Form I-9. In the additional information field, you'll have the remote inspection completed on the month, day, year. And then when you complete the physical re-inspection, you'll have the individual representative writing COVID-19, documents physically examined on month, day, year by the individual. Again, initials are okay if it's the same person physically reviewing them now who reviewed them during the initial completion of the I-9. And then on the next slide, we'll show you what it looks like if the person is different. So if the individual is different, then you would say physically examined by the HR manager, Betsy Ross, or by Betsy Ross, HR manager, or Betsy Ross, designated representative, whoever that person actually is. So those are some examples to hopefully help you with notating on the Form I-9 that the physical inspection has completed with the documents being physically examined. The alternative is actually the alternative procedure for reinspection. And this alternative procedure is a virtual review of the documents as opposed to sitting in person with the individual to do a physical review of the documents. This alternative procedure requires that the employer be a qualified employer. And what does this mean, right? This is something new that the government has defined for us. So the employer must have been enrolled in E-Verify at the time that they completed the remote or virtual inspection of the employee's identity and work authorization documents. The employer also has to have created an E-Verify case for the new hire, and the initial review that was done virtually must have been conducted between our significant dates, which are March 20th, 2020 and July 31st of 2023. All right, so what is a qualified employer? The qualified employer is also defined as an employer that is enrolled in and in good standing with E-Verify. So that's just a shortened version of it. And what does good standing mean, right? It's something that E-Verify, which is USCIS, has provided guidance on their website. And how they're defining good standing is that the employer is enrolled in E-Verify with respect to all hiring sites that are using the alternative procedure to remotely examine documents, that the employer must use E-Verify to confirm the eligibility of newly hired employees in the US, and the employer complies with all of the requirements of the E-Verify program. So essentially, the employer needs to be enrolled in E-Verify in compliance with the requirements of that system and all other requirements, which is a broad statement. We don't have specific information about what everything USCIS is thinking about with respect to the all other requirements. So that's something that we don't know at this point in time. And it is something that the American Immigration Lawyers Association's Verification and Documentation Committee is asking the government during a liaison meeting in the fall. So hopefully we'll have some further information for you on that, because one of the questions that we have is if an employer is not in compliance with all other requirements for the E-Verify program, does that mean that E-Verify will reach out and say, oh, if you've missed a few creating E-Verify cases for a few new hires, does that now mean that you're not in good standing? Is there notification that will be issued by E-Verify's monitoring and compliance section that will actually give an employer a heads up so that you're not all of a sudden caught off guard by being considered an employer not in good standing? So as we receive more information from the government, we will ensure to update everybody on that information. So we can go further into what else is required for the alternative procedure. So one of the requirements, and this again is for reinspection, the employer must be enrolled at every hiring site in the US that allows virtual verification under the alternative procedure. The employer also has to offer the alternative procedure consistently to all employees at the hiring site or to none, right? So the big thing, especially in human resources, is that we always want to be consistent with our policies. So you can have a situation where the hiring site in San Diego is going to use the alternative virtual procedure, but the hiring site in Dayton is not going to use the alternative virtual procedure. You can determine it based on hiring sites, but if you're using the hiring site in San Diego and you want to use the alternative procedure there, then you have to be consistent and allow all employees to use the alternative procedure at that particular site. And then the employer's E-Verify users must undergo E-Verify tutorials on fraud awareness and anti-discrimination training. So those trainings should, at this point in time, we've been told that are up and available for new users. For those users who have already gone through the trainings and now you're working on the alternative procedure for reinspection, you are not required to complete those new fraud awareness and anti-discrimination tutorials. We'll see if the government is going to make that mandatory for employer users going forward. But as of now, if you've been an E-Verify user and you've already gone through the tutorials, you don't have to go back and take the new fraud awareness and anti-discrimination training unless it pops up the next time you log in and they make you, go through that as the process. So what do we do now that we have confirmed that the employer is a qualified employer and you want to use the virtual verification process for your reinspection of those employees that were hired between March 20th, 2020 and July 31st of 2023. So these are the specific process steps that you would undertake. Again, it's going to be similar to what we talk about for the new process for new hires. But when you're doing the alternative procedure and you are, in fact, a qualified employer, you tick off all the boxes that you can use this process. Then what you're going to have to do is communicate with the employee that you need them to send you securely, make sure that it's being sent secure, copies of the front and back of their list A or list B and C documentation, right? So those documents will be sent securely email or a secure upload. One of the questions is, how do we know if the document has, something on the back side of the document? Just have employees, as a general rule, and to hopefully make your life easier, have them copy the front and back of each document that they provide, even if the back is blank, because you don't necessarily know that it's blank unless you have a copy. So just to make it easier and to get, to not necessarily get all those questions about, well, my document doesn't have anything on the back. Do I still need to send it to you? Just make a blanket policy, copy the front and the back and provide that. Those documents have to be submitted in advance so that the employer representative can review the documents. And then the employer representative is going to schedule with the employee a time to do the live video interaction. And what happens during that live video action? It is similar to what you have done in the past when you're completing the Form I-9. You're going to look at the documents that the employee provided to you securely and in upload, right? So you review those digital versions of the documents. You'll compare them to the individual who you're looking at virtually, either through Microsoft Teams or Zoom, Google Meet, FaceTime, whatever the video means that you want to use. It has not been dictated by the government that you can only use a certain system, so you can use anything, but your employee does have to have their video on, right? Because that's the point of it, is you need to look at the individual and make sure that the documents they presented look reasonably like the individual who presented them. And then you're going to update the Form I-9, indicating that you've used the alternative procedure to examine the documentation. If you're using the October version of the form, you're going to write that information in there. We have some examples that will be coming up. If you're using the new version of the form, there's a box that can be checked. And then the last thing you're going to do is retain the copies of the documents that the individual provided to you. Again, the front and back copies of the documents. I understand that your policy may not be to retain copies of documents. So if you're using an alternative procedure, you must retain copies of the documents. If you are using a physical procedure and you don't retain copies of the documents, if that is your policy, you can have two separate policies so that you're in compliance with the alternative procedure. Okay, so what if you did e-verify and you, with the individual, you did the virtual review, right? Instead of just having the individual email you the documents back in April of 2021, but you actually did something that is almost identical to what the government is telling you to do now for the reinspection, you still have to do it again. You have to complete the reinspection because there were several agencies that were in essence negotiating how this was all going to happen, how they were all going to be satisfied with a reinspection process following the end of COVID-19 flexibilities. And while it might seem redundant and to a certain extent ridiculous, if you've already done the same exact procedure that is required now for the reinspection, you do need to do the reinspection. You would have to do that over again. So just be careful about that. And again, it's just because of the negotiations that went on with the different agencies so that everybody feels good about keeping fraud to a minimum. Okay, so that's our comment here. So let's see a couple of examples. Here is the October 2019 version of the Form I-9. If you're using this version of the form to do your reinspection, you'll note here that you have the notation about your remote inspection was completed on and the date, which would have been the day that the original I-9 was completed. And then you would write in alternative procedure, examined on the month, day, and year, and then the initials of the individual. If it's the same person that's doing the virtual review that did the alternative procedure virtual review that did the initial virtual review. And if it's a different person, you would use their full name and title. Right, so we can go on to the next section here, which is the example on the August 1st, 2023 version of the Form I-9. If you're using this version of the Form I-9 to do your reinspection, you would check the box down in the bottom. I would also, notate documents virtually examined by the name of the individual and their initials or their full name and title. So we have some common questions during the reinspection process. And these are questions that we've seen for the last few months while this reinspection process has been in place for employers. So can the employee present the same documents that they presented when the Form I-9 was initially completed? Yes, they can. Absolutely. If the document that they presented in April of 2021, let's say that was their date of initial hire, was April 21st of 2021, and they provided a US passport that expired in July of 2021, they can still present that document to you for reinspection. The key is that the document must have been valid at the time it was provided for the initial I-9 inspection. So what if an employee, can they present different documents than those that they presented at the time of completing their Form I-9 initially? Absolutely. The employee has the discretion and the right to provide to the employer whatever list A, B plus C document they want to provide. Right. So if they provided a list A document originally, but now they want to provide a B and C document, what are the requirements if the employee presents different documents from those they presented for the initial completion of the Form I-9? You just need to make sure that if it's a list A document, it's a valid list A document, meaning it's still valid. It has not expired on the date that they're providing it to you for reinspection. And that it's also one of the documents that's listed in the list of acceptable documents as list A, or if they choose to present to you a B and C document. So just be aware that an employer can present to you whatever documents they choose to. If they present documents that they provided initially, those have to have been valid as of the initial time that they provided that to you in the last few years. If they provide different documents, then those documents need to be valid now at the time of reinspection. All right, so these are some questions that we have had come across our desk in the last few weeks. So what about employees that we have already reinspected in person? Again, if you've already reinspected them in person, you don't need to do anything again. So just a little bit of background on this. The government had, in fact, said you can do the virtual, review of the documents, and then once the person starts coming into the work site on a regular or consistent basis, then their documents should be physically inspected within 3 business days. Again, we didn't really know when people were coming back regularly, or if they would come in, maybe not come back again for a month. So a lot of employers waited until we had this deadline implemented by the government. So if you already did the reinspection, let's say that your employee was hired in April of 2020, and then you did the physical reinspection in January 2022, you're fine. You don't need to do anything again. You already met the requirements that you needed to for the end of COVID flexibilities, right? If you used an authorized representative to complete the Form I-9 for a remote employee, are you still required to complete a reinspection now? No, you are not. The review by the authorized representative in person is completely acceptable, and it's one of the options that USCIS has provided for a very long time. But a lot of employers didn't realize that or really start using the authorized representative until the COVID times. So that would be fine to move forward with not doing a reinspection if you used an authorized rep initially that physically reviewed the documents. What about when you're completing the reinspection process? Do you need to go through E-Verify again? No, absolutely not. Please remember that E-Verify is completed only upon the initial hire of the employee. So you would not put somebody back through E-Verify if you already created a case for them when they were initially hired. So this reinspection process, think of it as just dealing with the Form I-9. So you've already done E-Verify, you don't do E-Verify again. You're just working with the Form I-9 in this reinspection process. What if we were not an E-Verify employer at the time of the initial document review that was done during COVID, but are now enrolled in E-Verify? Can we proceed with the reinspection via the alternative procedure, or do we need to proceed via physical inspection? Unfortunately, you would have to proceed with physical inspection because the requirement for a qualified employer is that you were enrolled in E-Verify at the time that you initially hired the individual. And the reason for that is, again, the government is using E-Verify as an additional way to ensure that the documents provided by the individual are in fact legitimate documents to prove work authorization. And the last question on this slide is, do you have to record the Zoom or Microsoft Teams virtual meeting when you view the documents with an employee for the reinspection process? No, you do not. There are no requirements in the regulation or anything else that's been posted in the M274 handbook that states that an employer has to record the virtual meeting, either in actual digital recording or notate it somewhere. You just notate it on the Form I-9. There might be some issues with state laws or different jurisdictions that would prohibit the recording of these meetings. So you definitely do not need to record these meetings from that perspective. You just annotate them on the Form I-9. We have a few more. Yep. How do we note the remote inspection and physical inspection language in the additional information field of Section 2 if the electronic I-9 does not have an additional information field? There are a lot of different I-9 software providers out there that do the electronic I-9s. So because their processes vary, I would recommend that you reach out to your electronic I-9 provider to see how you're going to have to document the reinspection. There are different processes that different electronic I-9 software providers utilize, and I don't want to mix anybody up with what one provider requires versus another. So just check with your provider, as well as, if you have additional questions, check with counsel. Another question that we have is on the new version of the Form I-9, there is an alternative procedure checkbox in the additional information field, and we'll show that shortly with our new I-9. But is E-Verify requiring that this new piece of information be transmitted to E-Verify? It does not need to be transmitted to E-Verify. This is for the reinspection process, and it's only to update the Form I-9, not to update anything with E-Verify. And then lastly, we are using a designated representative to complete our in-person I-9 review. Are there any issues with that? As long as you're completing everything properly and you have instructions to your authorized representative and you review the Form I-9 that comes back from the authorized representative to make sure that everything has been completed properly, then that would be absolutely fine to use an authorized representative for the in-person review of the Form I-9 in order to comply with the reinspection requirements. So let's see. We've talked a lot about different things with E-Verify, with alternative procedure, but what about an employer who has a different representative completing the physical inspection for the reinspection and who otherwise meets the requirements for the alternative procedure? Do they complete a new Section 2 on the August 1st, 2023 version of the Form I-9 in reference that the alternative procedure was used for reinspection? Again, if you have a different person that's doing the virtual review now than did the initial review, I strongly recommend putting that person's full name and title in the additional information box, even for the alternative procedure where you're checking the box that you're utilizing an alternative procedure. And then this is a common question. What if we did not have copies of the front and back of original documents when we completed the initial Form I-9? Can we still use the alternative procedure to complete reinspection for those employees? Yes, you can. The government had previously said, keep copies of the documents, but if you don't have them, that's okay, as long as you're a qualified employer who's eligible to use the alternative procedure. then at this point in time, you want to make sure that you keep copies, obtain and then keep copies of the documents presented by the employee. I'm going to go to some questions from our participants. So this question is for U.S. passport page, does the front and back upload rule apply? So for the passport page, for purposes of reinspection, you would be copying the biographic page of the U.S. passport. For E-Verify purposes, an employer is actually required to maintain copies of certain documents, such as the U.S. passport card, permanent resident card. And in that situation for E-Verify, they also want the copy of the page with the barcode. So definitely for the reinspection process, you want to keep a copy of the biographic page of the U.S. passport. You can do the barcode as well, but it's not required. See, another question that we have is if we offer the alternative procedure to all new hires, but the employee elects to show the document in person, is that allowed? Are we then required to keep a copy? So that's a really good question. It's going to take us into our next section talking about the process for the new I-9. But for purposes of this, if the individual says that they want to do a physical in-person meeting, then what has been stated in the rules from the government is that the employees do have that option to say that they want to do a physical inspection as opposed to a virtual inspection. So an employer should accommodate that. If you do not maintain copies of documents for your physical in-person review of the documents, you do not need to keep copies for the physical review of the documents. So you'll be using a physical examination in this situation. And the last one we have from our participants before we move on to our next section is that after the reinspection process is completed, what process do we need to follow? The physical inspection process as was done before COVID? If so, how do we handle remote new hires when a physical inspection cannot be done? So it's a good question, and we're going to talk about that as we move on into our new section. So I'll answer that as we go through this. I just want to reference the slide that Anna had up that looked, this one, thanks Anna, that looked rather crazy. This is the flow chart, so to speak, of this reinspection process. So it's very, very tiny, but you can blow it up, and we found it helpful to kind of keep things in line. So just something for you to look back on that hopefully will help you if you're still navigating your way through the reinspection process. And so with that, we'll move forward now to the alternative procedure for new hires. And this is the new process for the Forms I-9 beginning August 1st, right? So can we use the alternative procedure for new hires? When you're completing the Form I-9 for new hires as of August 1st, you can do a physical inspection, as we always have done, or you may utilize this alternative procedure. The alternative procedure is only available to employers who are qualified employers, right? Those are employers who are enrolled in and in good standing with E-Verify. And again, what is good standing? Enrolled in E-Verify with respect to all hiring sites where you're going to utilize the alternative procedure. You're going to use E-Verify to confirm eligibility of newly hired employees in the U.S. And then you're going to comply with all other requirements of the E-Verify program. So going forward, you can use the regular physical inspection or the alternative procedure. Again, the alternative procedure, the employer has to be enrolled at every hiring site where you're going to use it. You have to offer the alternative procedure consistently to all employees at that hiring site or to none of the employees at that particular hiring site. And then if you're a new user to the E-Verify program, you'll have to go through the tutorial that talks about fraud awareness and anti-discrimination training. Please note that if you have different people who are completing the E-Verify case creation and putting that through E-Verify, and you have somebody different who's completing the virtual review of the documents, it's only the E-Verify user who has to go through the tutorial for anti-discrimination training and fraud awareness. You would think that the person doing the actual review of the I-9s virtually would have to go through this process as well, but it isn't. It's just the E-Verify user. So if those are two separate people, then it's kind of odd, but that's the way that the government set it up. So we'll see if that changes and any nuance going forward. Okay, so with the alternative procedure, same process that we talked about. Employee has to send you first copies of the front and back of the documents that they want to use to prove their identity and work authorization. You, as the employer, will review those documents to ensure that the documents appear legitimate and reasonable. And then you're going to conduct that live video interaction with the employee. And it's during that period of time that you will look at the digital docs and the individual, kind of like as if you were a person, make sure they relate to the person who's sitting there conversing with you, and that the documents are valid, they appear to be genuine on their face. Again, you still are not required to be acting like a law enforcement officer, right? So you just want to make sure they look genuine. Then you're going to check the box on the Form I-9 that you've completed the alternative procedure to examine the documents. You want to retain copies of those documents, and then you also want to make sure that you complete all steps for E-Verify as you normally would, right? So that's the alternative procedure. Here are some examples. This is the new Form I-9. You're going to check the box in the additional information section of the form in order to show that you've utilized the alternative procedure, and you being the person who's actually reviewing the documents, and then you'll sign Section 2 certification that you've reviewed the documents. And then what if you're still using the October 2019 version, right? Because right now we're still kind of getting used to this new Form I-9. It's not required to be used. Some electronic vendors don't have it in their systems yet. There's a lot of things that they need to do in order to get that up and rolling. So if you are hiring somebody today and you want to use the alternative procedure and you have the October 2019 version, then you're going to make sure that in the additional information field, you'll put alternative procedure examined on, and then the day and the name and title of the individual who's doing that review. So now our new Form I-9, which you've seen a little bit of it with what we've talked about so far, but some important things that you need to know. The new Form I-9, it's the edition August 1st, 2023. So it has now been live for 31 days. You can continue to use the October 2019 version until October 31st. So remember, you have until Halloween to use the 2019 edition. But as of, we call All Saints Day or Day of the Dead, November 1st, you're going to have to use the August 1st version of the Form I-9. Just like the 2019 version, our new August 1st version is also available in Spanish. Remember, this is for employers that are located in Puerto Rico. So the Spanish version can only be used by employers who are located in Puerto Rico. Okay, so what has changed, right? What's new with this August version of the Form I-9? Well, it's back to one page. We've had a 2-page document for over 10 years. We're now going back to a 1-page form. The instructions have been pared down to 8 pages from what had been 15. The preparer translator section is on a separate page called a Supplement A. And then the rehire, re-verification, and name change is on a separate page, Supplement B. And by moving those to supplements, that's allowed the government to shrink the I-9 back down to 1 page. Another big change is we no longer have alien indicated on the Form I-9. So if you recall, there's 4 boxes. I call them the 4 boxes, just easy for me to remember, box 1, 2, 3, or 4. We're looking at U.S. citizens, U.S. non-citizen nationals, lawful permanent residents, and then it used to say aliens authorized to work in the U.S. It now says non-citizens. So that's a big change. And it's a welcome change as far as I'm concerned. They're not aliens. We also have smaller fields if you're using the paper version of the Form I-9. So you're going to have to write really tiny to get all the information in. And that's one way that they were able to shrink the form down to 1 page. Again, with so many employers that are using the electronic version of the Form I-9, the smaller fields on the paper version should not be a big deal because you'll be completing them online. But just if you ever have to use paper, you're going to have to write very small. One of the other really big changes is that NA for not applicable or not available no longer has to be included in the fields. I don't know about you, but that's been a tough one for all these years to do audits and say, oh, the NA has to be in this field. You can't just leave it blank, but going forward, they can be left blank if they are not applicable. Again, the alternative procedure box for virtual verification is in the additional information field. That's one of the major changes. That's also one of the reasons that the new Form I-9 took so long to be released. They were trying to work on that simultaneously. And then lastly, the list of acceptable documents, which we refer to as load, is still not comprehensive. So those are some of the changes, the big ones for the new Form I-9. Just as a reminder, I always recommend reading the very beginning of the Form I-9, right? We have the Form I-9, it's valid until July 31st of 2026. And right here, the government says, start here. Employers must ensure the form instructions are available to employees when completing this form. Employers are liable for failing to comply with the requirements for completing this form. See below and the instructions. So you always want to make sure that you provide access to the instructions for the employee completing the Form I-9. For the electronic I-9 software program, the instructions, there's usually always a hyperlink, so you should be covered. But if you're using the paper version, make sure you include those instructions or tell the employees where they can access them. The other big thing to note is the anti-discrimination notice. The Department of Justice's Immigrant and Employee Rights section is the agency that deals with any kind of discrimination in the Form I-9 process. So that would be for document abuse, which means requesting more documents or telling employees what documents to provide. If there's any citizenship or immigration or national origin discrimination, which may be considered illegal. So again, it's just a reminder that you can't discriminate in the I-9 process. Right, so here's the new version of the Form I-9, right? Again, it's out as of August 1st. It is not mandatory until November 1st. So we still have a grace period to use the 2019 version. And if you're not sure where to find what edition it is, you look in the lower left-hand corner. No, you're good, Anna. Thank you. So we'll look at section 1 of the new Form I-9. It's all the same fields, but as you can see, everything's kind of squished together. The 4 boxes where an employee checks off their appropriate status are all there. And then if you remember, an employee also has to provide, if applicable, if they're a non-citizen, they provide their USCIS A number, I-94, or passport number. Those fields have been really shrunk down instead of taking up a huge section of the form. So that's really important that the employee completes all of this in section 1. And then section 2 has also been shrunk down. The additional information box is a little bit bigger, and we have the checkbox down in the lower left-hand corner of that additional information box. The fields for the first day of employment, remember that used to be in the middle of the language for certification. It's now over on the right-hand side. So you do want to make sure that you complete that. For years, it was kind of hidden and then it was not. And now it's in a different area. So don't forget about that. And then for the business address, it's all in one field right now instead of separate fields for the street address, city, and state. So you're going to have to squish it in there. But if you're an electronic I-9 user, this shouldn't be a problem. It should still be easy to fill out. And then we have, moving forward, just let's look at the new box, right? Here's the new box. You're going to check that box if you're using the alternative procedure. One of the questions that we have on our AILA verification and documentation committee, what we're asking the government is if failure to check this box is a substantive violation or a technical violation. We're kind of leaning towards it. The government might think it's a substantive violation. So be really, really careful. And if you're using the alternative procedure, make sure you check that box, right? Because that's how ICE is going to know in an audit if you did the virtual review or a physical inspection. So don't overlook that. So the next thing that we have is the list of acceptable documents, right? So this list of acceptable documents is the same list, but there's 2 things to note that are a little bit different. It's in blue. There are hyperlinks that are pointing the individuals to where you can see examples of automatic extensions of EAD cards. And then at the bottom, there's just a general link to the I-9 Central. Please note, as an employer, your job is getting a little bit more difficult for individuals that have different documents, right? That are typically those individuals who are non-citizens. there are roughly 50 documents that are acceptable that are not specifically listed on this list of acceptable documents. You'll find information about them in I-9 Central. It can be very confusing. So for any of those, you can reach out to the WR team or to your counsel to kind of understand if a document that's being presented that's expired is actually acceptable, given all the automatic extensions and different versions of documents that the government has been coming out with in the last year or so. So just keep that in mind. All right, section 1, I'm going to go back to section 1. The bottom of the old version, the 2019 version of the form, had the preparer translator section. And if you know, it was kind of one of those things where you're like, oh, the employee forgot to check the box that they were using a translator or preparer. Or if they weren't, they had to check that they were or they weren't. Now going forward, there's a supplement A. Supplement A only needs to be completed and retained if the individual is using a preparer or a translator. That preparer or translator will put the employee's name in those top fields, and then the preparer or translator will sign and then provide their name and their address, not the company's business address, but the preparer or translator's address. It could be the company's address if that's where the person is, but they can't use a PO box in here either. But again, this only needs to be completed if a preparer or translator is being used. If not, you don't need to worry about supplement A. And then we also now have a supplement B, which is the former section 3 for rehire and re-verification, as well as for name change. So in this supplement B, the employer would put the employee's name up in those top fields and then complete the appropriate information. If it's a re-verification, they complete the re-verification information. If it's a rehire, complete the rehire information. And if it's a name change, if the employee has a legal name change, you would complete the legal name change here. One of the things to note is that in the instructions on this form, which is the bolded black language, the instructions say that you would complete this form if the employee provides proof of a legal name change. Please note that proof of a legal name change was never required. It was optional. So if an employee came and said that they have changed their name legally, you would complete section 3, in this case, supplement B, with their new name. You would only need a name change document if you need that for purposes other than completing the Form I-9. But again, we being the verification committee are checking with the government during our liaison meetings in order to understand this better, because this has never been a requirement. So I just want to point that out to you, that you don't have to require proof of a name change from an employee. Right? So that's a little bit confusing there. So one of the questions that we have, I was ahead of myself. I talked about the name change, so that's one thing. And then the other thing that we have is with re-verification, right? When re-verifying an I-94 record, so that's the I-94 arrival record for individuals who are non-citizens, and the I-94 document is evidence of their work authorization. In essence, there's no physical aspect to it anymore, because CBP at the ports of entry aren't producing a card, right? They just put the information online and you can print it out anywhere. If it's attached to the I-797, then as an employer, you would know that you sponsored this individual and there's an I-94 at the bottom of it. So is it okay for the employee to email the I-94 record to the HR department for re-verification? This is something that kind of depends on a case-by-case situation. I mean, the government has said in the instructions and in the regulation that the employee has to present the original document for re-verification. So you should see the original document for re-verification. The assumption that we have is that if you're the employer who sponsored the individual for an H-1B or for an O or for a TN, you know you've sponsored them. So can you look at the copy of the Form I-9? It's better to look at the original if you can, but if you're the employer who actually did the sponsorship, then in that case, looking at either the I-797 with the new I-94 attached to it before you turn it over to the employee is acceptable. But if you have a situation where the employee is receiving a new EAD card, then you actually have to review that EAD card in person, the physical card, and not just a copy of it. And this is assuming that you're doing the physical inspection. If you're eligible to do the alternative procedure for re-verification, then that might be acceptable. Again, stay tuned for some updated information as we get it from the government. Okay. We have a couple questions here. I'm going to answer these, review them so that we can answer them before we get to the very last part of what we're going to discuss today. So are there any states that do not allow E-Verify? And if so, what are your options for I-9 verification after the re-verification deadline? Is the only option a physical inspection by an actual employee of the company? So there aren't any states that do not allow E-Verify. E-Verify is a federal program. There are some states that do mandatory requirement of E-Verify for certain employers in those states. But if you are enrolled in E-Verify and you were enrolled during the time that the individual was initially hired, then you can utilize the alternative procedure, again, as long as you're a qualified employer and you follow the process. And the other question that we have is, are there any concerns or limitations with using E-Verify in the state of California? Several years ago, there were a couple of cities and municipalities in California that mandated E-Verify. And then California said, no, you can't mandate E-Verify. So those regulations went away because the state overruled them. So in California, there is no mandatory requirement to utilize E-Verify. If you are a federal contractor and there's a clause in the contract that requires the E-Verify, which is known as the FAR clause, then you would have to utilize it. But if you have employees in the state of California, you are not required to use E-Verify. If you don't use E-Verify, then you cannot use the alternative procedure, right? The alternative procedure is only available for E-Verify participants. And the reason for that is that the government agency wanted to make sure that they were trying to limit any potential fraud and abuse of the virtual review of the Form I-9. So the E-Verify was a compromise that the agencies agreed to when they allowed for this alternative procedure. So if you're not enrolled in E-Verify, you might want to consider the proposed DHS Pilot Program. And what is this? Well, ICE released this shortly after, when was it? I think it was the very beginning of August. And it's a proposed non-E-Verify pilot program. And that's, again, for employers that are not enrolled in E-Verify. This is not in place right now. It is something that was just announced in the Federal Register for comments. Who can use this? Employers with 500 or fewer employees. The employers will need to complete a form to participate in the pilot. And that form was on the prior slide. It's small. It's just a one-page form. But participating employers will have to provide data to the government up to twice a year. And what do they have to provide? They're going to have to provide numbers of new hires, the number of employees asking for physical inspection, and their challenges as an employer to the use of the pilot program. Also, employers will have to examine and retain clear and legible electronic copies of the identity and work authorization documents, similar to the alternative procedure for E-Verify employers. Also, employers are going to be required to implement other measures to ensure security, such as fraudulent document detection and anti-discrimination training. Whether that will be training that ICE will put forward or it's going to be on the USCIS website, we'll have to wait and see how they're going to implement that, but it's going to be pretty much the same training that E-Verify has for their E-Verify users. And the other thing we have to look at is that for those employees on site, they're at the same physical work site as the supervisor or in a hybrid capacity, the employer may be barred from the pilot or given a time frame following the initial remote document examination to be subjected to physical examination, during which they will physically examine the documents and compare to those on file. So basically, this is saying that the government is going to be watching over the employer to see if they can actually continue with this program, okay? And then the last thing is that Department of Justice's Immigrant and Employee Rights section Again, that's the section that looks at any kind of discrimination in the I-9 process. Will have the right to inspect the forms, I-9, and the retained documents. So pilot participants will be subject as well to the I-9 audits, which are conducted by ICE's Homeland Security Investigations. Those are the I-9 audits where you can be fined, right, if you don't have an I-9 or you have a substantive violation. But also now you're going to have IER looking over those forms I-9 to see if there's any kind of discrimination that's taken place. Those are the pilot programs, and we have 30 seconds for Anna to provide additional information, but I'll also say, don't forget to check out the resources, your WR team, the M274 Handbook for Employers, E-Verify website, and I-9 Central. They're all online. And the Handbook for Employers has been updated recently, so make sure you check that out if you haven't looked at it in the past few weeks.
Okay, thank you, Kim. I'm launching the poll right now to remind you guys, if you would like SHRM credit, make sure that you respond to the poll so that we know we need to send you a certificate with your credit. That will take us about a week to get to you. Similarly, we'll have the video and the PowerPoint slides available to you via email within the next week. And any other questions, we will follow up with you guys after the fact. Thank you so much to Kim and for all of you for attending today, and we'll see you next time.
Happy Labor Day, everyone, and good luck with all your I-9s.